It's day 13 and we've got conditions and obligations to get through today. Just a couple of points to pick up on. So we had the site visit on Friday and it was really useful. So thanks to all those efforts involved in organising that. The site visit stuff has been added as an inquiry document, as a formal record of where we went. And just to confirm, I also walked back over London Bridge because we agreed that I'd do that bit unaccompanied, so I wouldn't be going backwards or everyone wouldn't be going backwards and forwards in the heat. And then yesterday I went up to Hampstead Heath. I took a picnic. It was very nice, very hot. So I have picked up the last couple of like longer distance viewpoints as well, which was helpful. And I could see there was no haze, which was good. It was helpful and a relief having trudged up there in the heat. And I did, just to confirm, I came back into the office in the morning, so I had all the documents and the views and stuff that we were looking at on Friday as well. So just to confirm that. And then also off to the Shard today at 3:30. So I'm hoping we'll get conditions and obligations come by then. So there we go. So we've got a few new faces then. Few returning faces around the table, so welcome back everyone. For those that haven't been, can I just ask you to email Joanna Vincent your details, because I'll need to make a formal record of who you are, qualifications, etc., for the decision, for the recommendation report. It's usual proviso with conditions. So we're going to start with conditions first. It's usual proviso, so it's without any prejudice to the council's or Historic England's or TfL's case. I know a lot of work has gone into these. There's been a flurry of emails in my inbox this morning and late last night. I'll go through which set we're on, just so we're all working off the same set, because there's been a few different versions flying around, and I'm hoping everyone will have got there as well. I am a stickler for conditions, so I did make my early chapter comments. I don't like repetition and lots of unnecessary detail, but I've obviously had the helpful note in response to my track comments as well, which we'll go through, and I'll use that as a basis for the discussion today. So I thank the council for that note. And I have seen the reply from the appellant's team in response to the council's note as well, so I'm aware of the views of them. So I think we'll go through 2018 conditions first as the basis. We'll get to the 2021 scheme, but we'll just then focus on the different ones because there's so much overlap between them. Is everyone ready to begin? I think today, because we're quite a busy room, 3 people can have the microphones on at the same time, so we may just have to switch on and off and have a bit of fun and games with that as well. So we'll see how we go. But if it's flashing green, someone needs to turn the microphone off. Okay. So thank you for the note. So I'd made some I'm hoping everyone's seen them. I made some very brief, in shorthand, sort of tracked comments next to each condition. Most of it was about consolidation of conditions. And I think the overarching response back, and I think it's just probably a sign of how my brain works versus how the council do things, is in terms of the grouping. So I know the council have sought to group in terms of the trigger points, just to make it easier to enforce, etc. I think my brain works better with topic groupings, and I think that's probably where the difference is between us. So I think if we just have a broad overarching discussion about that, and I'll kick off with the council first, just in terms of just those principles of why you've done it. And I appreciate it's a big scheme, and I know that there's different elements to the building. So there's Keats House, there's the tower block, and then there's the listed terrace. So I do appreciate it's quite a complex site. It's a big site, it's a big scheme. So I can understand, and the note was helpful in in setting that out. But I think if we can just discuss sort of the council's preference to retain that grouping rather than my suggestion of combining the conditions more as a point of principle, and then we'll go into each. Okay.
Thank you. I think it's principally for the reasons that you've just touched on and those that we've tried to articulate in our notes. In sort of structuring the draft decision notice, we've tried to be mindful of the way in which the development would proceed. So both the council and the sort of consultant team for the appellant can keep track of progress and understand where the development is up to. And secondly, I suppose it's with the knowledge that in delivering schemes of this nature, the appellant is likely to draw on different teams of contractors to deliver different elements of the site. And that might mean that the people with the responsibility of actually addressing these conditions, it falls into those sort of divisions as well. And so it's just a practical suggestion, I suppose, on our behalf to how this might actually be delivered and how the various parties can best keep track.
And your view is very much you'd like to stick to how they are set out and laid out as existing. Wouldn't be happy if I sort of try and sort of group them or anything.
Well, I think in terms of content, there's little difference. So I'm not sure we have a particularly strong view on that. If you're minded to recommend things done a bit differently, then that would be okay. In terms of the council position, it's just entirely the practical perspective, and with the full knowledge that, you know, if this scheme is to be delivered, the people around this table might not be those involved in delivery as well.
Okay, and if I come to the appellant's team, just for comments on the sort of the broad structure.
Yeah, thank you. I've got David Shields from DP9's planning consultant with me as well. So
welcome.
David will help and pitch in from time to time. But I think the general principle is really, as Mike just set out, we're happy either way. We do tend to find that on these kinds of projects, and particularly in central boroughs, so Southwark, particularly this way of the subdivisions with the titles can be very helpful in terms of discharge, because otherwise if we amalgamate too many of the conditions, there can be a bit of an issue sometimes with partial discharge of individual limbs. So we find it is helpful, but I do take on board that it's quite a different approach to what you would normally see with a Secretary of State decision. So very much over to you, Madam, really, in terms of combining. And I think if a lot of the comments and the questions that you raised really did all relate back to the kind of overlap, or the sense of overlap when you've got the Tower, Keats House and Georgian Terrace at the back end. It may well be that you can bring them in, and as you also picked up, it's not intended to be it's not a sill phased permission. We haven't set out a sill phasing strategy, but the individual buildings will of course come forward with a slightly different programme. But there are linkages in terms of, you know, we've got occupation restrictions, for example, in the 106, which means that certain parts will all come forward at the same time because the affordable workspace, for example, has to be delivered. So there's no suggestion that there's a big time lag between different parts. So I think if you were minded to combine, it would work absolutely fine. But equally very conscious that the council are trying to manage the practicalities of discharge.
Thank you. I'm conscious we've got other people with us. It's kind of a point of principle, but does any of the other parties have any comments to make on any of that? No, shaking heads. Okay, thank you. All right, well, shall we go through them then? Probably a little bit of a forensic exercise, but it's just good for me just to get an understanding, because obviously either way I have to report them to the Secretary of State. So let's just confirm which list we're working from to start with. I know there's been lots of work. So if I'm looking at the 2018 scheme, I commented on a set back in July, which I think was version 1. And then the latest version I've got is version 2, I think, according to what's on the bottom of the front page. Does everyone have those? Yeah.
So I think the version that you commented on was before we submitted a new version that was agreed between the parties that reflect changes to the list of building consent and also incorporated some specific references to the hospital.
So yes, I think that was, yes.
So is it best to work on that earlier version or the more recently submitted? The more recently submitted was on the 4th, Thursday evening.
Yeah.
Which I suspect is what most people probably got.
I think if we work with the up-to-date one, and then if I've got any comments, because obviously the note goes with my original version. This is going to be a nightmare today, isn't it? So we'll just, we'll see where we go, and just tell me if I'm on about the wrong condition or anything, and jump in. Okay, right. So has everyone got the latest set? Just so I'm happy that everyone's seeing the same. It's Transport for London. Have you got? You're looking. Oh yeah, the first few probably don't concern you, but yeah, shout if we go ahead and you want to come back to anything. That's fine. Okay, right. So condition 1, standard, absolutely fine. That's easy. Condition 2, I'm assuming the plans have been double checked at the correct references, just as a point of principle. Yeah, nods, thank you. Okay. Condition 3. So I did make a comment on this about duplication with condition 55. I was quite satisfied actually with the council's explanation of that, but is there any more comments on that particular clause? So it relates to the parking spaces and loading bays. Would it be better if we got you a paper copy? Yeah. Could we? Could we get a paper copy just for a spare, or? I mean, is that going to leave you without? Because I'm happy to. Are you sure? Because I'm happy to pause if need it. Okay. Okay. So I mean, that one's just basically ensuring that the bays and the parking space and the loading bays are going to be there throughout the lifetime of the development. Okay. So I didn't. Yeah. Now I had the explanation. I had no sort of further comments on that one. So condition 4, a works element plan. So I've not come across one of these before. So I queried whether it was like a phasing plan, which it's not intended to be. But perhaps if Mr. Glasgow can discuss that.
Yes, it's not quite a phasing plan. I think the intention of this condition is just to ensure that some of the disparate elements of the scheme come forward as a collective, to make sure that works to the Georgian Terrace and Keats House do keep track with works to develop the principal tower. And for some of the reasons that are referenced in the conditions, to do with ensuring that we don't have a prolonged gap in the street scene along St Thomas Street, given the sensitivity of the context. And I suppose it's one of the reasons we alluded to a little bit earlier, in that the 106 is quite complex in its scope and requires or includes a series of obligations on the timing of occupation of different elements. So this is an opportunity from the outset just to present a programme for delivery that gives confidence to all parties that the scheme would develop in a sort of coordinated fashion. But it's not intended to be a phasing plan in the context of the civil regulations.
Yeah, okay, thank you. Anyone else, any comments on that? No, it's exciting stuff. Silence today. Okay, all right. And then we come to the management plans. So we've got the demolition management plan, the construction environmental management plans, and condition 7, construction logistics plan, and then demolition of buildings condition. And I sort of just commented about whether these could be amalgamated due to overlap, and then later on there are transport and highways management plans as well. So obviously council's made comments about wanting to keep them separate, but I think if we can just touch on that, please. So Mr. Glasgow.
Yeah, so I think over the years the council have approached this in both ways, with a sort of consolidated condition that wraps up environmental matters and logistics, and now this way which addresses them separately. And I think we've found that particularly for larger scale developments, it makes sense to present the conditions in this way, just because of the number of issues that the management plans tend to broach, firstly. And again, secondly, because we tend to find that different parts of the consultant team submit these documents, whether it be an environmental specialist or a transport specialist. And just in terms of the discharge process, the council would consult very different people on each of these plans. So environmental management plans would be typically with the input of the environmental protection team, whereas the logistics plans would go to the highway authority, whether that's the council or Transport for London. And I suppose just to give you a bit of confidence over the content, the conditions that you see here, they have evolved over a number of years with the input of those parties. I think the criteria that you can see in conditions 5, 6, 7 do reflect the input of the parties I mentioned. And I suppose just picking up on the point that Louise made earlier, if we were to consolidate these conditions, I don't think it would fundamentally change what we would see, but it might mean that we do enter into the realms of partial discharge of conditions, or we might find that a particular plan that's submitted addresses highways issues very well, but environmental issues less so, just because of the nature of the author who's prepared it. And so I think it's one of those areas where we think there's a logic to the way in which the conditions have been presented, but if they were to be consolidated, I don't think we would mind too strongly.
Any comments?
Not really. The only thing I was going to pick up is, whilst we're talking about this condition, that there was already there is a version where we'd already put in a specific reference to the hospital in 5B, and then in response to further comments from the hospital, there's been a request to put in an additional reference in A, in consultation with Transport for London and the hospital. I'm probably making your point, sorry, Phil. And that's obviously subject to a response from the council, but just I think it seems to make sense to me to try and wrap up the additional changes that are happening as we go through. But in terms of the question, we would be happy if you chose to consolidate, but we would reiterate the council's position that it's very standard in Southwark to see it done like this. So in terms of their teams that monitor and discharge, they're used to seeing it in this way. And I think that does help sometimes. But
yeah. Great. Mr. Villas, did you want to pick up on the point about 5A?
Yes, thank you. Just really briefly, and we do welcome obviously the fact that there has now been inclusion, reference to the hospital. In terms of protecting the hospital, I think it kind of makes sense from our perspective that at the very least there's reference to them being consulted, because sometimes there is consultation around condition discharges, sometimes there isn't. I think just for clarity, it would be helpful to have that specified, because it is so important, that relationship between the two sites and the nature of what happens on the hospital site. Potentially there are some quite big impacts, and the point of these conditions obviously is to mitigate that as best, as far as possible, and therefore some consultation reference with the hospital I think would be really helpful. It's not to make this more sort of burdensome or bureaucratic, but it might actually help even during the drafting of the submissions by the applicant, it would be helpful to have a consultation. That might happen anyway, but certainly once the submissions are received by Southwark, we're helpful then to obviously have some consultation around that. So just for clarity's sake, I suppose, we welcome that if possible.
Okay, does the council have any points on that?
Well, I suppose just to offer a little bit of reassurance, as you can imagine, all sorts of major development happens around the borough next to sensitive receptors, whether that be the hospital or schools or nurseries or residential for that matter. And so the council is very familiar with addressing neighbour impacts through environmental management plans in particular. I suppose if a document was submitted with the wording I have in front of me now, I would expect the officer looking at that to consider the impact on the hospital, but they wouldn't undertake any consultation. It would just be a consideration along with the other neighbour impacts. If there is a strong sense from the hospital that they want to be included as a direct consultee, I don't think we have a particularly strong view there if that's what you're minded to recommend.
Okay, so you wouldn't be objecting to just an additional reference?
No, I don't think so. But there'd be a standard requirement for this management plan, as there is with all management plans, that the council consider that there is ongoing engagement with all neighbours, including the hospital, through the delivery of the project.
Okay. I think because they're mentioned elsewhere anyway, I think it probably wouldn't hurt just to put them in A. So I think if we can get that done, that would.
So Mr. Villas provided comments on an email as opposed to specifically. So what we had thought about was just to add in the reference to the hospital within that bracket and the third line of A. So after in consultation with TfL.
Yeah.
I assume that works.
Yeah. Okay. All right. And then in terms of the wider point, I take the point, the conditions have been, you're not just written them up for this inquiry, they're sort of long-standing local conditions that are well used and known. Mike, I kind of one concern is, and you sort of touched on it, you say different teams might see different conditions. What if, because some of them overlap in terms of I think wheel washing, for an example, if one condition says, one plan says one thing and one plan says another thing, who's looking at it all? And that's the issue with sort of having the repetition, and then which condition has primacy, I guess. I mean, I don't know if that's an actual real risk or it's just something in my head, but that's the more repetition there is, the more risk that there's divergence, I guess, and then how that's dealt with. So I don't know if there are any thoughts on that.
I think that would fall back to the case officer managing the process. I mean, whereas there'd be different consultees given the content of the documents, I would imagine that both of those conditions will be looked at by the same officer at the council in the planning team. And so they'd be able to have that sort of coordinating role. I suspect the instances where there is overlap is relatively limited. I think wheel washing is probably one of them.
It's quite a specific example.
Yeah. I mean, there may well be others in the context of demolition and construction as well, but there would be a point of coordination within the planning team on those matters.
Sorry, I was just checking in to make sure that
fine.
My understanding was correct, which is that it's really rare, I think, certainly on the schemes that we work on in London, to see them combined. It did used to be that way, but we do now, as standard, submit separate demolition and separate construction. Some of that is because of bringing forward to allow that demolition process to happen with minimal pre-commencement conditions, so that works can start, because often the demo phase is quite long itself and it gives you time to be satisfying the other conditions. Is that reflective?
Yeah, I think, as Michael touched on as well, is that the reality is that when they are combined in other boroughs, we end up part discharging the condition.
Okay.
I think having them separate is probably a more practical and cleaner approach, to be perfectly honest.
That's fine. And Transport for London, any comments? Because this, obviously, you're named in the conditions, and
Well, I've seen hundreds of these things. They're always different. If there's a CLP, CMP, CLMPs, every borough does differently. I think from our perspective, it's just as long as the information's in there.
You don't care. Yeah.
And also, I think the point about the combined demolition and construction, I've seen cases recently where we've had applications for splitting them up retrospectively. So, because of that very issue, that developers want to demolish first, separately. So, but in terms of CMP versus CLPs, I guess as long as the information's in there, that's all that matters. Really.
Yeah, and you're named as well. As part of that. Okay. All right. My arm's been twisted then. Okay. All right. The condition 8, I think we've dealt with all the management plan ones. Would you have a point? Sorry, no.
I'm just going to do Mr. Villard's job for you. Okay.
After you, though.
Are you sure? I was only going to suggest the drafting that we'd come up with, or at least have that conversation, but it is subject to everything else until the guys' comments came in yesterday, I think, had been agreed with all the parties, but we haven't had a chance to discuss with Southwark the suggested responses to Mr. Villard's comments. So that at 6, there was a request. We'd already put in at F, where there was a neighbouring commercial occupier. We'd put a specific reference to the hospital in there in terms of what the CMP would include. But there's been a request, as before, to extend that consultation in the actual approval of the document up front. So again, we'd suggested, if you were minded to do that, the language would go in at the 3rd line. So again, in consultation with Transport for London and I know the council had the same point as before, I think, but.
Yeah, I suppose if that's what the hospital wanted, it makes sense for that to be repeated in the suite of conditions.
Yeah, just I suppose it then makes the consistency across all of them. So I'm comfortable with that.
Save 7. We jump ahead to 8.
Yeah, 7.
Yeah. Well, it's the same point, isn't it? I guess.
So 7, I hadn't picked that up from your comments. I had thought that at 7 you wanted an inclusion at 7J.
It was a slightly different point, actually.
Yeah. So that was one where it matters. This is the construction logistics plan, which is much more highway focused. And at J, it requires liaison with construction teams of neighbouring sites. And we were going to put in there, including.
Okay. Yeah, that's fine. That's sensible as far as I'm concerned. Okay. All right. 8. So demolition works to Georgian Terrace, Keats House, existing office building. So I commented saying, could this form part of the demolition management plans under 5? I did get a response back from the council on that. Do you want to just
I suppose on this one I might just defer to the appellant, actually, only because I think this falls into the category of a condition that would just fall to a different party on their side. I think that the demolition management plan being a very practical, here's how we intend to undertake the activities, this being something that sits behind that to give the council comfort that the requisite contracts are in place to take forward the works to the terrace. So it's from a sort of heritage perspective rather than a practical.
It's important, obviously, that the tower block wouldn't get developed without the others being the list of buildings being sorted. So I do get the point. It's it's just my quest for brevity, I guess. But did you have any comments?
I thought this was a slightly different. I'm sorry, I'm trying to scan across 3 documents, but I thought this was a slightly different point here, which is that if you think back to conservation area consents as was, and now the planning permission's wrapping up those requirements, I thought this was to protect the council much more from a heritage perspective, to make sure that we didn't start demolition and then stop without having that construction contract in place to build out, which in a conservation area I would expect to see on the planning permissions. And normally that is quite a separate requirement. You could wrap it in as another limb, but it isn't usually seen, as far as I know, within the demolition management plans, which are very much technical, construction-y type stuff. This is a commercial issue. Do you have your construction contract to ensure that once you start to demolish, you then are going to carry through on a certain program and build out? So this is, I thought, to protect that kind of statutory position in terms of management of the conservation area. So ordinarily we see them separately. Again, if you did want to merge them, we're fine with that. But I think that one particularly, to me, has a rationale to stay standalone.
Okay. Do you want to comment, Mrs. Dring?
Yeah. Obviously, this is one of the conditions that we were particularly interested in, and certainly so far as the listed buildings, the terrace are concerned. This type of condition is obviously one that's specifically mentioned in the Act in relation to listed building consent. So at one point, our position was that perhaps the aspect of it that relates to the terrace should be split off into the LBC. The council weren't keen on that. We're happy with it all being wrapped up together in the planning permission, and for the reason just said in relation to the conservation area as well. I think HE would have a strong preference to keep this as a separate type of condition because of the specific role it plays from a heritage perspective, rather than wrapping it in. But obviously our main concern is the actual content, so long as that remains. But that's we're in agreement that it should be a separate condition.
Okay. No, I'm happy for that to stay then in that respect. Okay. And then Condition 9, protection of the Georgian Terrace Keats House and Coney Bear house facades during the works. And I just commented again in my quest for brevity whether how does it work with Condition 4, which references the assets. So I don't know. Too much paperwork on my desk. SC6. Just talk me through that one.
Yeah, I don't think there's any interaction between the two conditions. I mean, we touched on Condition 4, just talking about sequentially how the scheme is going to develop and just giving reassurance that it's a coordinated plan of action, which means that no parts of the overall development would lag behind to a great extent. Condition 9 is a more detailed account of the interventions to those heritage assets and the way in which the works will be undertaken to ensure no harm arises, is my understanding. So they're serving quite distinct purposes, I think.
Okay. Any comments?
No, I don't have any.
No. Okay. All right. Okay, that's fine. 10. So these are the archaeological conditions, and I did ask if they can be 10, 11 and 42. I think the preference is 42 remains separate, but 10 and 11 are combined, and I think that's not been done in the latest draft. Is that correct?
Not the latest draft that you've seen, but it has been done. But to be fair, was only circulated this morning or last, I can't remember.
Okay.
There's a version in which we've done an attempt so that can then just check that they like the way it's been set up. But
but parties are happy with that one. Yeah. Okay, fine. So then, Condition 13, London Underground Asset Protection. It was just, I highlighted excluded site clearance, but then it was providing demolition and construction details, and I just wondered.
That was an error on our part. We've agreed, all the parties have agreed to take that out.
Okay, that's not changed in my latest version. That's to be done.
Post dates your comments.
Okay. All right.
Can we just come back to condition 12?
Oh yeah, no, sure. Yeah, sorry, I'm jumping ahead, but sorry. Yeah, no.
It was only just to say that that's another one where the hospital has asked for consultation. If it were to be agreed, the suggestion, if everybody likes it, is that it would be in the second line. So the BIA would be submitted and approved in writing by the local planning authority in consultation with.
Okay. Yeah. Any views on that?
Well, I'd like to invite Mr. Villas just to explain, I think, what the benefit is of the hospital being a consultee on this particular condition, because I'm not entirely clear.
Yeah, I think it's simply to do with the potential impact of these works, which are quite significant on quite a long boundary, which affects more than one boundary in terms of the operation of the hospital. It's that simple, really. It's to ensure that there is some understanding of what the impacts might be and how these works are going to be carried out, hours of operation, etc. It's that simple, really. It's because of the particular nature of this neighbour. Wouldn't normally expect a neighbour to be consulted in that way, as in specified in the condition, but I do think there are circumstances here which are somewhat different from that.
Okay.
I think that's fine. I thought that might be the case. All I would say is that this is quite a specific condition, looking at the impacts on groundwater. It's the sort of thing that normally is prompted by consultation responses by the Environment Agency. So those sorts of issues around general amenity and construction impacts will be wrapped up in the conditions we've already talked about on demolition management and construction management. So I don't think there's a particular role here, or there's going to be a submission of details that would be of interest to the hospital.
I do accept the point that it would be a broadening of that condition, actually, towards amenity as opposed to groundwater. I do take that point.
But you'd still prefer to be...
Well, ideally, I don't think this is significant as the other points, the other conditions. So I think we'd leave that with you, Mark.
Just coming back on that point, though, that does lead to overlap, because unless it was very, restricted to what the condition at the moment is addressing, which is the groundwater impacts, it would be covered already in those earlier conditions, which we have added in the hospital as a consultee. So I think if the idea is to broaden it, I would resist that, because I think that is overlap.
Yeah, that's fair.
Okay. Okay, I think given it's a very specific sort of flooding condition, I think the hospital's interest would be covered better elsewhere. So we'll leave that one as it is. Okay. Okay. Yeah. So number 13, London Underground asset protection. So that was the wording that I just picked up on. Any comments from yourselves just while you were on the table?
We're debating whether or not excluding site clearance should be there on the basis that these are assets that need protecting. And during site clearance, there could be some unfortunate things happen that need to be controlled and managed.
I think that was my sort of concern, because it talks about demolition later on, but site clearance to me was the same thing. But I think is that being resolved?
Yeah, the words would be deleted, so it would read in the brackets, excluding site investigation works.
Okay. Yeah. That satisfy?
Yeah.
Okay. Okay, thank you.
Before you turn the page,
Yeah.
I don't know how your pages are set out, but at 14, that was another request from the hospital, and I suspect we're going to have a very similar point as we just did on 12, in as much as adding consultation. We've got here, it's piling. The consultation is already with Thames Water and the Environment Agency, and it's very much about contamination and risk of piling. We would suggest, as above, that it's really covered already.
But it does say, and due to the proximity of listed buildings within and adjacent to the site which may be affected by the piling works, obviously that would incorporate the hospital as a 2-star building. Do you want to say something, Mr. Villas?
Well, I think certainly from a heritage perspective, but also from a general, again, amenity point, I think piling is different from what we just discussed under 12, groundwater. I do think the method of piling, as this is specifically to do with that, is important. Obviously, with different techniques, the impacts vary vastly. So I do think that this is a really important one because of the nature of the work and the proximity of the hospital. I prefer that the hospital was included in this one.
Does Historic England have a view, just while the appellants team are having a think?
We no, essentially.
No. Fine. That was simple.
I don't think we're opposed. I do think, having just read that through, that the reason needs to be updated, because the reason is very specific to contamination, and about, proximity to water utility and that kinds of things. Oh, it has got historic.
It has it, so D in the condition.
I was just referring to the reason, updating that, but actually it does reference the historic buildings and the reason. Sorry. I mean, we are easy. If the change was to be made, I think it would be in that bracket. So it would be adding the hospital as a consultee. We could try and limit that to Lim D, or we put you into Lim D only. I'm essentially easy. We're happy to do the right thing, and I think, as Mr. Villas said before, the client's team will be liaising with the hospital anyway.
Yeah.
And I'm sure, to the point that, because piling will be covered in those earlier plans as well, so I'm sure the point will be picked up. But if you did want to add it in, we're not going to resist that.
I agree, it's sort of belt and braces, but I think to avoid any doubt, because it talks about the method, it talks about the listed buildings. I think it would be helpful to include.
Yeah, I mean, so obviously I'm just thinking out loud here. So obviously there's the grade 2 King's Head pub as well, and actually on the site visit the owner did come out and try and talk to us and said, well, am I going to hear about what's going on? And sort of we dealt with it, but obviously piling as well. So I'm happy for a mention specifically of St Guy's, but obviously there are other listed building owners that would need to come under that. So as long as it's not exclusively St Guy's, I guess. Not St Guy's. I'm sorry, I keep doing that. Does council have any comments?
Probably nothing to add on this one. I think primarily, again, it is about the impact on groundwater, because piling can create a pathway down to groundwaters, and so this is something the Environment Agency normally insists on. But I do acknowledge there's references here to the impact on listed buildings and to the MPPF paragraphs on protecting the historic environment. So if this is an area where the hospital would feel it beneficial to be involved, then I think the council would be okay with that. In terms of the wider engagement with local people, local receptors, that would be covered in the CMP.
Okay, I think
just to follow up on that, I think this was one of the conditions that we were in earlier discussions with the council on. I think we suggested adding in references to the listed buildings in this condition because specific concern, because the proximity of the site, particularly to the terrace, and concerns about vibrations. I think that's a sort of, it was originally just focusing on the groundwater issues, and it has then been broadened to take in the issues about vibrations and the effect on listed buildings, which would obviously include the hospital, because that's adjoining the site, and the terrace, and also the pub as well. So just by way of just following on from what was just said there in terms of why this is now covered in that condition.
Yeah. Okay, I think, well, I'm happy for a reference to go in under D, just to sort of say, in brackets, including Guy's and St Thomas. But obviously I wouldn't want that just to be limited to them as a consultee, but I don't think we need to set out everyone, because it's just say listed buildings. So is that okay? Site contamination. Again, this is my quest for brevity, because I asked if this could be amalgamated with conditions 28 and 33. And again, the concern about mixing details and sort of partially discharged conditions applies. See, council's preference to keep the conditions separate. Any comments around the room on those ones?
No, not especially. This is another example of a condition that, so in the past, the council have combined and had as a single one that ranges from the desk-based assessments over to the validation reports at the end of construction. I think the way in which it's been presented now is just as a result of practice in Southwark over the years, and trying to align it with a different stage of development.
Alex, have any views? Content?
No, same again. I think it's practical.
Yeah.
The way it's drafted.
Okay. All right. I'm not doing very well here, am I? Okay.
Madam, can we just before we move on, just so that we know that we're agreed, can we just come back to the wording of that condition before? And if we add into limb D, this is condition 13, piling, so it would read measures to prevent and minimise potential damage to listed buildings within and adjoining the site, including without limitation guides in St Thomas's Hospital. So we're adding it there as opposed to putting a consultation at the top. Is everybody happy with that? Yeah.
Are you? Yeah. It's quite a specific point. I think it would fit better in D.
Yeah, we do too. Thank you.
Yeah. I'll come to how we deal with sort of changes at the end and consultation and everything, but yeah, okay. Okay. 16 then, drainage strategy, and I guess it's a similar point. So I asked if it could be, well, I asked how does it work with condition 34, and could there be any potential for combining these?
But I think this is where we start to get to the point that it's about the overall structure of how the conditions have been set up, because at the moment there is an ongoing compliance section which inevitably causes this overlap or site duplication, but it does separate out the limbs of the condition which require ongoing compliance. Now, with my, obviously, I think I've always got my lawyer's hat on, but with my lawyer's hat on, when we're advising incoming purchasers, funders, anybody else, we're often asked to confirm compliance with whatever condition. Now, there'll be a discharge notice on the system that says that condition's been discharged, but if you read it very carefully, often there is an ongoing compliance requirement. Has that been discharged? It can't really have been. It shouldn't have been, and it does lead to confusion. So from our perspective, we think the approach is quite neat, but it doesn't apply everywhere. Most boroughs haven't picked up on this yet, so it is less usual, but we like it.
Okay. Any comments? No. Okay. Okay, fine. So yeah, then we're down. There's the hostile vehicle mitigation and the blast mitigation impact assessment conditions. Now, I just commented on these because I've just not come across them before. It's obviously reflective of the world we live in nowadays, unfortunately. And obviously, I know there's been, it's in relation to sort of the police and the crime and disorder implications. Is that a fairly standard thing for the borough now, sadly?
Yes, unfortunately it is. I think it's something which is led by the Met Police, and they have certain thresholds, I suppose, where they start to introduce this issue as being a relevant consideration. And where they do, it's something that the council's happy to adopt.
Let's carry on.
I think that's all I need to say.
Yeah, unfortunately, we see it particularly with tall buildings, particularly in the City of London. This is very standard, and increasingly as tall kind of goes to other areas of the boroughs. But it's not only, so the blast mitigation impact is quite specific to tall buildings, I think.
Yeah.
In my experience, that's about strengthening the frame, making sure that the structure of it in the event of a blast, essentially, and this came out of, I think, even as far back as some of the island bombings. It's been around for quite a long time in central London. That's about the structure of the building, as I understand it. The HVM is more common where you've got potential access, or where you're opening up pavements such that theoretically a vehicle could come on to site and actually impact people. So that's where you get your bollards in consultation with TfL, and if you walk around the City of London, you'll have seen the bollards everywhere, some of which are at developer request, because they're, if you look at Goldman Sachs building, completely framed because they're so security conscious, and others are at the request of the authority. So I think they do have two quite different purposes. You could theoretically combine, but the consultation is different and the measures are quite different.
Yeah, I don't think I was thinking of combining the two anyway, but no, that's helpful. Does TfL have any comments on that? I know obviously you'll be familiar.
Well, we see them all too often. We end up with them outside our own buildings. But they are very unfortunate in terms of footway widths and whatever, but unfortunately they're necessary.
Yeah. Okay.
That's the problem.
All right.
And they are two different things as well. I mean, we would not be interested in blast mitigation. We are interested in hostile vehicle mitigation because where they go.
Okay.
And it's perhaps also, sorry.
I think in this case, there are no bollards on the TLR either, on the highway. I think you're all off on site rather than off site, which is
all on site.
So that's why we're not interested in this. If that changes, obviously it would be, but
Yeah, I suppose for the avoidance of doubt, the way the conditions drafted assumes that they're within the applicant's demise, within the public realm. If they were to start to encroach on the footway for whatever reason through the detailed design process, then I guess they'd form part of a 278 package.
Sorry, it's framed. Thanks, Sam. They will be subject to detailed design anyway, and it's worth remembering that they can come in all different shapes and sizes. So often it would be part of the landscape planters. So the actual planter boxes are the HVM mitigation.
Rather than just the kind of really industrial sort of looking ones that are there as a temporary thing that are put in quick. It's part of a sort of a scheme, I guess.
Outside, so in the city, we do have quite a lot of structural planters as well as bollards, but they're quite keen on bollards. But in other boroughs, it tends to be more hidden, so you wouldn't know that they're there, but it's in the framework of tree boxes, planters, etc.
Yeah, just picking up on a point, you said you'd be interested in the hostile vehicle mitigation, not necessarily the blast mitigation impact assessment. You're actually named in the latter and not the former, because of the underground. Are you happy not to be mentioned in the former? Do you consider that necessary? I don't know.
If they're not going on TNRN, the highway, then we don't need to be involved.
Okay.
If they are, then
you
obviously we would be concerned.
Yeah.
And yes, the basement
blast mitigation rolled off the tongue.
That's an LU specific thing. So
okay.
That was the change made to that condition, actually, was to specify the location off the TLRN, so that TfL, because originally TfL did request consultation on HVM, but that was how it was changed. It will be on site.
Yeah, to make it more specific. Okay. No, that's fine. Okay. I didn't have any comments on, we've got 19 full fibre connectivity, 20 fire safety. I think I'll pick up back on that later, so we'll come to that later. 21 whole life carbon, and 22 circular economy. I don't have any questions on those. Are there any points to raise while we're here from anyone? No? Okay, good. And then got condition 23, hard and soft landscaping. I think I'll come back to this because there's like bat boxes and things that I've said could that be combined into this one, but we'll pick up the bat box condition, I think, rather than this one. I didn't have any other specific comments to make. I do have a point on the section 106 and overlap, but I'll pick that up in the section 106 section as well, just trying to keep things neat and boxed off. Okay. Cycle parking. I just had a few queries about pre-commencement and notwithstanding being in there, but that has been explained to me quite well. I don't know if anyone had any points on those.
It's a TfL comment, and it's, I think, driven by the fact that that detailed design hasn't been done and will be done as part of the section 278, and where the cycle stands are currently shown they haven't been through their process of actually agreeing that's exactly where they'll go.
Okay. Any comments on? No. Okay. All right. Thank you. Um, 25 then, secured by design. Again, I am quite familiar with that. I did wonder whether there was overlap, but I know what you're probably going to say, and I'm quite content actually. I think so no comments on that one specifically. No. Okay, 26 and bird boxes. I do tend to see those ones in a landscaping condition, so that's the point of my querying that one. Comments?
Well, firstly, I would agree. This comes back to that structural approach where we're now into part 3 of the conditions where it's above grade, and that's why it's been separated out, because the landscaping strategy will be submitted and discharged earlier, and the bird box piece is prior to installation of the ground floor slab. So that's why it's been pulled out and put in here, because of the timing of discharge.
I'm just looking at the landscaping condition just to remind myself.
Part 2, pre-commencement.
Mm-hmm. I mean, this is one I do feel a bit more strongly about, because it is just, obviously important, but it's not such a huge thing. I don't see why it couldn't be done pre-commencement, just sort of identifying what they are and where they're likely to go. Any views?
No, not really. I think quite often the hard and soft landscaping condition is an above grade condition as well. I think in this case it's been made pre-commencement just because there's a need to increase the greening on the site to meet the sort of minimum urban greening factor specified in the London plan, and that might require some additional tree planting. And so the council's wanted a bit more assurance over tree pit details and soil depths, that sort of thing, which means that it necessarily has to come before you reach ground floor. So bird boxes is in its sort of normal place as an above grade condition because that's not necessary detail earlier on in the process. If we wanted to amalgamate them here, I don't think we'd have any concerns. It's just as presented, it's just a way of allowing the appellant to do a bit more work before the council receive those details.
Okay. Ditto, I think. Very well said, thank you.
I mean, I just, I think this one I'd like to combine, actually. I think it would just make more sense, and it's such a small sort of detail in the overall scheme, it shouldn't cause anyone too much of a headache, unlike some of the other issues which I'm happy to concede on. So I think if that one can be put into that, and I'll leave you to sort out words to that effect. Okay. And then condition 26, 7, public realm management plan. I have questions on this in terms of how it works with the obligations, which we'll come to later. And then then it talks later about a landscape management plan as well. I was just a bit confused by this condition, so I think if we can talk me through it.
Very easy win is that we all agreed to change it from public realm to landscape.
Okay.
The title of it we agreed in response to your question. The parties agreed that change already.
Okay, that was easy. Yeah, okay, that's fine.
I don't know, Mike, if you want to talk about potential merging into or how it sits separately from the landscaping condition above, and then, as you said, perhaps we'll come back to the Section 106 piece later.
I mean, in terms of sort of amalgamation, I don't have any real concern if that were to be amalgamated with the hard and soft landscaping conditions as a sort of final paragraph. I suppose a bit like some of the ones we talked about already this morning, the longer term management of the overall landscape would likely sit with a different party. And so in terms of ongoing compliance, as Louise mentioned earlier on, perhaps there's a rationale there for keeping them separate, but it's not something I don't think the council's particularly strong view about.
I think, to be honest, I suspect the reason for this is because you'll see that it's from 15th floor slab. Now, that came certainly from our landscape architects in terms of when they would be ready to have that level of detail. And that's why, thinking about it, it's come into part 3 as opposed to part 2, which is the pre-commencement. I'm just looking over at Hayden, who can't see me. Is there a strong view still from the landscapers, Hayden, on that timing?
Issue is just
What your opinion?
Sorry.
Could you bend it over just so it picks you up?
Yeah.
Thank you.
Yeah, sorry, the issue is just about getting the right level of detail, especially when it's potentially got a lot of stakeholder engagement in order to make the submission, because you're normally looking to do the discharge having really kind of agreed in advance with all the relevant parties that it's the right approach, rather than put something in and then assume that the consultation process will throw out lots of answers that you try and deal with. You try and deal with it the other way around. So I think, generally speaking, that's a reasonable timescale.
You've just turned your microphone off, I think.
I'm so confused. There is a question in terms of that overlap, because management and maintenance is picked up under the Section 106. So I do wonder whether we flag this and perhaps
come back to it. I was going to say that because I want to refresh my knowledge of this 106 over the break, because there does seem overlap, and obviously if something can be dealt with by condition, it should be a condition rather than an obligation. But they have sort of slightly different roles. But should we park that one and come back to it to see how that all fits together?
Sense, because reading through, I think a lot of it would be covered either under the landscaping in terms of design,
or then the management. Yeah.
But I don't know whether the council. It is quite standard in Southwark to have that as a condition, and there is always the Section 106 long-term management. But I can see an argument to say that there's duplication there. I suspect Southwark would rather keep it in the Section 106 because there's a level of detail in there which isn't captured here. But we can talk about that later.
Yes, I think we would, Adam, we would prefer that was covered in the Section 106, which is a standard approach in Southwark. I know that's not necessarily an acceptable reason for saying that there could be a degree of overlap. But if we could have a look perhaps in the session at the detail.
Yeah.
then that would be helpful.
Yeah, it was one of my questions I'd flagged. So we'll reflect on that and pause over the break and then come back to it. Okay, thank you. Okay, condition 28 verification report. That's with regards to remediation. We've discussed that at the earlier contamination condition. Condition 29, I had no comments on. Does anyone have any points to make on it? Water network infrastructure? No. Okay. And then 30, flood risk management. Again, I just asked how it worked with condition 35 and whether it could be combined.
Another one where we come back to the parts, because 35 obviously sits within part 5, which is the ongoing compliance.
Yeah, okay. You've twisted my arm on that one then. That's fine. Okay. Um, 31, restriction on use class. Obviously, PPG says you have to have good reasons for restricting what would be permitted development ordinarily. I mean, I had no particular comments on that, but I didn't know if there was just some explanation for the reasons for that I can note down. Putting you on the spot here, aren't I?
Yes, I mean, I suppose in practical terms, there are only several parts of the scheme where this might really apply, and we might be worried about the implications of change of use. And I suppose they get to the heart of some issues we've discussed throughout the appeal, because the value of the terrace is sort of providing animation on St Thomas Street and providing affordable workspace is obviously fundamental to the scheme has been put forward. Provision of gym floor space, as you'll see through the conditions in here, is a very specific issue where the council has over a number of years now tried to make sure they have the right framework in place to properly understand and evaluate the impacts of that particular use. And so I suppose just given the sensitivity of the site and the nature of the uses that are coming forward here in this location, it's a way of giving the council some comfort that any particular changes that might change the dynamic or introduce new uses will be subject to consideration by the planning framework.
Any other comments on?
Certainly TfL in this, particularly this context with the TLRN so nearby, would welcome the opportunity to assess different uses within Class E, because the TA has been done on the basis of the proposed uses, and some of the other things that fall within Class E have very, very different transport impacts.
Okay, thank you.
Yeah, we have no intention to bring forward uses other than those that we've made an application for, so we haven't at any stage pushed back on this condition. In a way, whilst most of my clients do try and push this, in a way it is helpful, because coming to the point that Anne's just made in terms of the environmental statements, the broader Class E, particularly for the 2018 scheme, because of course that wasn't even a thing at that point in time, they haven't been assessed on that basis, so that there aren't the wider ranges to give the upper maximum levels in the event of any other use within Class E kind of coming forward, which we would normally do if we were trying to secure a Class E general permission.
Yeah.
So these have been, both schemes have really been assessed as predominantly an office with the other uses coming through. So we're content on that basis.
Okay, thank you. That's helpful. Okay, refuge storage. Glamorous. I don't have any comments on that. Important as it is, but and then Condition 33, unexpected contamination. Again, we've had that debate, haven't we, already? Number 34, surface water drainage, similar point, unless anyone has any comments on them. And the same for flood risk as well, number 35. So, no comments. Okay. Opening hours, number 36, I didn't have any issue with that. 37, yeah, I read that wrong. But I do have a point, and it relates to the 106. So terraces, what is the meaning of terraces in terms of this condition? Because the 106 sets out opening hours for the use of the gardens. And I just wondered, what's the difference here, just in terms of being precise?
I think I'm right in saying it's a difference between those terraces provided solely as an amenity for the occupiers of the tower building, whereas the 106 is dealing more specifically with the public gardens.
So we did address this. So in the I thought we'd somehow missed it in all the various iterations, but in the 2021 version of this condition, where we've got the roof garden, to be very clear, that condition does exclude the roof terrace. So it is the other terraces which is captured. The 2018 doesn't do that because there is no other terrace. The garden is obviously the enclosed. Well, I say that it has got the outdoor space at the front. Maybe we need that same wording to come across just to clarify that.
I think this is why I was just a bit confused, and you know, it have to be precise. So yeah,
I was going to say there are, in the 2018 scheme, there are terraces which are associated with the hub, and there is also an office occupied terrace right at the very, very top of the building. So there are spaces within the scheme which are, as noted here, specifically related to the office use rather than public use, but they are in the scheme for avoidance of doubt.
Yeah,
and they're the ones which it's intended to pick up. So I think what has happened is we specifically addressed this point for 2021 and didn't think about the external part of the public garden, so didn't on 2018. So I think if we added in to that condition 37 for 18, the terraces and balconies of the tower building, open brackets, excluding the terrace associated with the public garden, close brackets, that would probably
cover it.
work.
Yeah. Council, have any comments on that?
I think in principle that would work. I think if we can just have the opportunity to double check against the drafting in the 106, and we'll just confirm.
Okay, thank you. Windows, number 38, I didn't have any comments on. Similar merging of retail units. I mean, that goes to the affordability point as well, I guess. But no comments from my point of view, unless anyone has anything they want to say. And the same for roof plant and telecoms equipment, really, unless anyone has any burning desire to comment on roof plant. Okay. And then, so part 6, trigger conditions, archaeology reporting. So we've dealt with that. So we're combining the other two and keeping that one separate because of the different trigger points. Plant noise, fairly standard. I no particular comments on it. Security equipment. So I asked whether that could be incorporated into the landscaping condition. Can't remember the response to that. So there was a bit of concession here, I think, in terms of councillor saying.
Yes, I think in the note we've said that we'd be open to that being incorporated into the landscaping condition. I think my only hesitation is just the number of elements being incorporated into that condition and the number of parties that will need to be consulted on. But there's no sort of in principle objection to that being amalgamated with landscaping. It would bring it much earlier in the process. So I suppose there's a practical point around whether the appellant would likely have that detail available so early on.
I think the reason that we would ordinarily want to see that prior to installation is because by that point you've done your secure by design consultation and had all the feedback in from the Met Police. So normally it's at the back of that process, whereas the landscaping condition is coming in on this scheme earlier than we would normally actually prefer it to come forward. And I just don't think we'll have had the process in terms of detailed design of the HBM, of the secure by design requirements to be able to give that information that early. So that would be my concern on it.
I think my sort of overall general concern is with all these elements, because there is a lot of overlap anyway, and sometimes some things get missed. And so you've got a beautiful landscaping strategy, say, and then the lighting scheme is like a add-on, bolt-on, because it wasn't thought about at early in, and it doesn't always sort of tie in. But I do take the point, and I imagine it will be thought about earlier on anyway. But yeah,
I don't know if this works or someone's going to shoot me down, but I wonder whether you could theoretically combine it with the secured by design, because wouldn't that cover the same elements with lighting and the design requirements?
I think it's a bit wider ranging in terms of the specifics that they'll be interested in.
You mean the secure by design one is wider?
To some extent, this is after slightly different things. So they don't quite align, if that makes sense. You'd be arguably better aligning this with the hard and soft landscaping design, but that's a condition that's now been brought a long way forward. So you'll get sort of stuck in you probably end up discharging it twice, which I think isn't necessarily in anyone's interest.
I think that's what we were trying to avoid, because there will be, let me just check the landscaping. I'm sure in the landscaping one it does list, does it list lighting at all?
I'm imagining a bit of a Venn diagram between secure by design, landscaping and lighting, but I think Hayden's point is right, that the condition here is sort of a two-part condition in some ways. It's looking at lighting from a security perspective, and so the Met Police would absolutely have a perspective, and that would have been hopefully aired through the initial conversations on secure by design. But the reference to the guidance from the Institute of Lighting Professionals is more heavily focused on amenity and lux levels at neighbouring properties. So some elements tie in very neatly with secure by design, and you would address that through the same conversation. But that wider point around glare, I suppose, and what the impact is on neighbours wouldn't be of interest to the Met Police, but would be to the Council's Environmental Protection team and planning team.
Yeah, I suppose there's design elements, there's security elements, and then there's amenity elements to it. So it is going to have some crossover. Okay, I think given that we'll leave. You've twisted my arm again. Okay. Number 45, Ream. So we got the new build and then Keats House in this one condition, and then we got the separate BREEAM listed building condition, which seemed to say pretty much the same. And I appreciate there's a split. And obviously the listed building rating, I think it's now agreed between parties. It would be, is it very good rather than outstanding? But that to me seemed to be the only difference. And I just wondered why it had been cut up in that way.
To be honest, in this instance, I believe Keats House and the tower are actually covered under the same BREEAM assessment, so they don't specifically have to be. In essence, they can't be split out, so they would be submitted jointly.
But I think the question is why the listed terrace sits separately. I suppose the answer, correct me if I'm wrong, is that there'd be a single BREEAM assessment against the new build methodology that the BRE have for those two properties, for the tower and Keats House, but the terrace would be subject to a different assessment, different report looking at refurbishment focused methodology. So yeah, they're the fundamental things. So if we were to group them, we'd probably be entering into partial discharge territory again. And this just allows the freedom for those two reports to be prepared by two separate teams.
Okay. Is that fully your, yeah. Okay. All right. Lots of arm twisting today. Dim use mitigation and access. Comments from me, queries about that. Fire evacuation lift. So I asked if that would not already form part of condition 20 anyway. Get the response that this is I think the multi-part condition, it could be combined. I think the point made about the slightly different London plan policies doesn't really make any odds. It's this combining site-wide conditions that the comment was made on. So I didn't know if there's any points to make on that.
I would have thought they can be amalgamated, to be honest.
Yeah. Great. Yeah. Okay, if you can go away and do that, then that's great. Thank you. There. Materials. I didn't have, so this is a tower materials, I think, and I do see the logic in separating out the materials conditions for the three different elements. Detailed drawings, I didn't have any comments on those for the tower. Same with biodiverse roof. And then I had a comment about the mock-up, whether that could be combined with number 49. That was again a practical point, I think, with timings. Yes.
I was going to say we would normally try, because the mock-up is such this kind of building. This is a very expensive exercise. We would typically want to ensure we've agreed the design with the council prior to committing to the mock-up. So it's just a basic timing, which is to run through and agree, yes, council's aligned, and then commit to the mock-up, because it's, it could be £500,000 or something in that region in order to carry it out. So
okay. But, yeah. Okay. All right. Okay. I didn't have any comments on 52, 53 and 54. So they're TV, radio and telecoms impacts, wind mitigation, kitchen ventilation for the tower. And the same with 55, actually, car park management. Any comments on those? No. Right, so then we're into the Keats House specific conditions. So I made a couple of points on this. The linkage with condition 9, just ensuring it was not too repetitious.
We had agreed to delete part B from this condition 56 and then just rely on the other one because we agreed it did overlap.
Okay, and that's agreed between parties. Okay, and then it was just a point, it's nothing to do with me, just that list of building consent might be needed, but that's in hand from what I see. Yeah,
there's two kind of pending live mini applications sitting with the council, which the assumption is that they'd be determined post this decision.
I think just for my report and just for the Secretary of State, I think if I could just have half a page of just what those applications are, just and there's just status and their reference number, just as a factual record for me, just in case any questions are asked on that, and it just sort of boxes that one off.
I think we did put something
in the statement of common ground,
or statement of common ground, but we'll dig something.
Yeah, if you can do an up to date, if it's in the statement of case, that was written quite a while ago now. Feels like a while ago now, anyway. So yeah, it'd just be helpful. It's just as a factual point. It's more than anything. Okay. Fire evacuation lift. Again, similar point to the others. Is that?
Yes, I think that can just be amalgamated into the site-wide strategy.
Yeah, that's okay. Perfect, thank you. 58, yeah, I got that one wrong, so thanks for correcting me. Keats will need kitchen extraction ventilation equipment, so that's absolutely fine.
Sorry, just I know Hayden responded for us, but the council had previously suggested that they would prefer the fire evacuation lift to stay separate. Are you happy for that to amalgamate?
Back to my safe construction on that detail point. I think some of the separation of conditions here has been to sort of reflect the way in which you would package up the details and send them through to us. But if we're amalgamating the previous condition that addressed this point, then maybe a logic in doing the same for condition 57. I'll just double check in the break.
Thank you. And then 59 materials samples. That's physical samples. So I was quite happy with that explanation given what's happening to Keats House. Didn't have any comments on condition 60, the detailed drawings. 61. So on my new list, that's crossed out. Is that correct?
Yes, that's right. So this comes from a conversation between the council and HE in terms of once we provided two different sets of conditions in the scenario that the listed building consent comes forward with or without a planning permission, there was a request to put that material sample condition for the Georgian Terrace onto the listed building consent. So to avoid duplication in the event where you have got the planning permission, they've gone across onto the listed building consents instead.
Okay, is that your understanding? That reflects.
Yeah, that's my understanding.
Yeah.
I don't know if HG wants anything else.
Yeah. Nods. Yeah, thumbs up. Good. Okay, fine. And then 62, the BREEAM report, on which we have discussed. I sorted that one out. Okay, that's the end of the planning conditions. Dare I ask any omissions on the basis of anything we've heard over the last 4 weeks? There's nothing. I usually make a note of things crop up when someone says, "Oh, that could be dealt with by condition." I haven't done that in this inquiry, but just to put it out to the room in case there's any glaring omissions in the condition. I mean, they're fairly big set, fairly thorough set, but
I think because all parties have been working for quite a long time on them, so it's been very helpful to have the input of TfL from the beginning, for example. And that's been
and I was going to say that at the end. Actually, I would echo that. I know you've all done a lot of work, and sometimes they're just forgotten and sort of left, to the last minute, and that's not the case here, which is good. Okay, all right, and then so listed building permissions, so much smaller set, which is good. I didn't have many comments on this. I noticed there was a request from Historic England about the inclusion from the planning ones to the list of building consent side. In the new set, we've got the material samples one. So has that all been resolved now?
Yeah, I think all of the points we've made were picked up.
Yeah,
I think there are obviously different conditions. There was the note earlier about the situation if the LBCs were granted independently, which therefore includes obviously more conditions in this scenario.
Yeah.
Many of them were included on the planning permission, but we were happy. Yeah, we were happy with that. So yeah.
Okay, perfect. I have no comments to make on the list of building conditions. Okay, great. I think. So we've got the 2012 conditions. I think, are there anything that's majorly different on them that we haven't already forensically gone over? Let me get my paperwork.
No, I've been trying to track both as we went through. There are a few very minor points of clarification, for example, like that roof terrace one that you picked up, where so they do slightly differ. The numbering is very slightly different.
Yes, I mean, there are different schemes and there's slightly different inferences there. But I think if the points we've made on the 28 scheme can be tracked across to the 2021 scheme, I'm fairly content. But if there are any comments on the 2021 scheme, I think, is there a different, because obviously the servicing arrangements are quite different in terms of TfL's point of view.
TfL have been working on both sets, and we've agreed comments against both sets.
Right, okay. Any points then to make on the 2021 ones to save us going through them all one by one? No. Okay, well, that's been really helpful. So obviously we've agreed. I like conditions because I can actually be directional and say what I want, which is good. It makes a change for me in an inquiry. So I think if parties can go away and make the changes as per the discussions today, agree them all with each other, and then we'll get them in as a final agreed set, and they'll be recorded as inquiry documents as well. How quickly do parties think we can do this?
They're pretty much done. So
very efficient.
So we've been doing it as we go along. Obviously we need time to. Everybody else will need time just to read over them.
Can I say by tomorrow, sort of, because we're closed tomorrow? It'd just be good to have them boxed out by then.
We'll circulate this afternoon.
Yeah. So. Yeah. Okay. All right. Any final comments and conditions? No. Well, thank you. I know it's not the most exciting part of the inquiry, but it is really useful for me, and it is good to just go through them one by one. So thank you for all your efforts. And as I have said, it is very apparent you've all been working really hard on them together and collaboratively. I think Bristol Airport, we got presented at the end with two very different sets, which was quite a nightmare to try and work out. So I'm not having that at this inquiry, which is really, really helpful for me. So I do thank you for that. So we'll have a break now. We'll come back and we'll jump back into the obligation. And I think there's some new versions of that. So I had a copy on my desk on Friday after the site visit, which is printed out, but there's a newer version of that, which I've got the copies of, just not the drawings, because there's an issue with A3 printing, I think. But I've got the drawings from the latter version. I think they're pretty much the same.
I think it's only the 2021 drawings we had problems printing. They have been prepared to be legible at A4 to be bound into the 106, but we can discuss that later.
Okay, that's fine. Yeah.
Actually, I think, Madam, we've now got the A3 copies.
Oh, right, printed
of both. So yeah,
well,
thanks to my colleague who sorted that out.
Okay, that's great. So I've got the ones I've got are dated the 8th of August in front of me now. So I did, when preparing yesterday, it was obviously against the previous version, but I don't think there's huge fundamental changes anyway. So we'll just sort of work it out as we go along. So if we break now, if we come back at past, because I think there's just a little bit of work to do over the break in terms of looking at the influence of the landscaping management sort of plans and how that all works together. So we'll come back at past. Okay, thank you. Okay, I know there's some musical chairs being going on. Is everyone ready? Mr. Philpott's sort of moving further down out the room. Okay, so we'll now go on to the 106, and we've got a new face.
Hello.
Hello. So do you want to just introduce yourself to the...
Yeah, good morning, madam. I'm Matthew White. I'm a partner at Herbert Smith Freehills, and I've been advising TfL on the Section 106 agreements.
Great. And can you provide your details? I'll have to record your involvement on the decision, the report letter. So
if there's an attendance list somewhere, I'll fill
well,
it.
if you could just liaise with the programme officer waving to you at the back.
Will do.
We'll get those. That's great. Thank you. Just for my record keeping. Okay. I think we'll do it as a similar exercise as what we did with the conditions this morning. So we'll go through the 2018 obligation, and I have got the updated SIL compliance statements from the council as well. We'll add those as inquiry documents in due course. You just get my notes up. So I think just some, obviously, two very big schemes, two quite different schemes in some respects. Quite a lengthy obligation document. So I didn't know if we just do a sort of brief, I'll put you on the spot here, but introduction to what it covers and contains. I know there's been negotiations going on right throughout the inquiry, and even as late as I think this morning from the email flurries. So I think if I can get an understanding of where we're at now as well with it, and we'll go through the documents, we'll go through the 2021 documents, and then at the end I'll sort of set out a timetable, and we'll have a chat about getting it signed, etc. So if I can start with the appellant.
Thank you very much. I guess the main thing, or the first thing really to say, is that it is based on Southwark standard form. So the first drafts for both schemes were prepared by Southwark, which was a request from us, and very grateful for that. And they have obviously been prepared as a tripartite agreement with Transport for London also signing up. We are now, I think, as of the last few minutes, I think we are agreed. So there are some new plans being prepared from comments that have come in from TfL this morning. There's some drafting that the inspector won't have seen, I think. Was it in that version yesterday?
So that was in the...
So it will be in the version that you saw yesterday, that's right, but the council at that point had only just been sent it as well. So that's on the flexible office retail unit and how that has an implication on affordable workspace. So there have been things going on, but that is now also agreed. So subject to anything that happens today and a final read through for some cross-referencing type things, we think that we're all in settled form. So that's been really helpful. The 106 is structured, again, I don't know, Margaret, if you really want to talk about your standard form, or if I try my best.
I'm quite happy for you to fire ahead. It might be helpful for you, madam, to know that a lot of the obligations that Southwark requests are set out in our Section 106 planning obligations and Community Infrastructure Levy SPD, which is core document CDE 04. And we've also set out the policy basis in the SIL compliance statements.
Thank you.
Yeah, so I would say that we've seen the SIL compliance statement. We've seen a previous version, but we've seen that just this morning. But I'm sorry, I wouldn't anticipate that we would have, I'm just going to silence my speakers, anything to add to it, but we haven't actually had a chance to read through. So the front end of the agreement does the usual thing, sets up the parties, their kind of rationale or role within the agreement. We have a scenario here where the station freehold is owned by London Underground Limited. So there had been conversation as to whether LU also signed up as an independent party, but it's been agreed that Transport for London would essentially do that and run that. And I think Matthew can probably speak to that a bit more later, but that's all been agreed. One of the main reasons to do that was just to provide some clarity and also certainty on the delivery of those station works, the opening up of the works. And there's been a lot of engagement with London Underground for quite a long time to agree detailed heads of terms in terms of those works. So they are settled and agreed. They're not as such bound into here as in the heads of terms aren't appended, but the Section 106 sets out an obligation as to what that has to do. You've then got, obviously, your standard in terms of all your definitions come front. You have your normal boilerplate provisions, really. There will be some changes to Clause 3 in both documents once the drafting finally settles. That's the clause which makes it conditional so that the obligations in the agreement don't kick in until the decision's actually granted. And then in addition to that, the obligations don't have effect until the development's been implemented. And in this scenario, it's worth saying that we've got definitions for commencement, which is material operation in the standard way under the legislation, and then implementation, which is a later trigger point, which excludes demolition works. It also excludes piling and excavation. Once they get to the point of actually construction, then most of the obligations trigger from that point forward. So that clause is subject to review. There are certainly a few which we'd in this version missed off and now need to be specified in there. We've got the usual provisions at clause 4 in terms of the Secretary of State involvement and the fact that whilst you will have a completed document, or no, a signed document before you, well, in fact, it will be a completed document. Obviously, things could change if you decide to strike something out or not put any weight on something. So those provisions set out at clause 4.
The blue pencil. I don't know why we call it a blue pencil clause. There must be something legal about it, but I can never understand. But...
We've got our blue pen. Essentially, so that the rest of the document will stand in the event that certain obligations are really, struck out by your theoretical blue pen. We have restrictions in terms of how the obligations flow. So ensuring that, end users of, for example, one of the small retail units wouldn't take liability across all of the obligations that come forward. And I don't think there's anything in there particularly that's different to what you'll have seen before. Lots of notification requirements which link up with the obligations, so to allow the monitoring teams to know what's coming and when. And enforceability. So the front end is very much, I think, is subject to any questions that you have, as you'll have seen before. And then the way that Southwark work their 106s, and they're slightly different, but then each schedule is generally grouped into a theme. The only schedule that perhaps is a bit of a mixed bag is Schedule 2. But the schedules go through financial contributions at Schedule 1, Schedule 2, which covers broadly highways, listed building consent, but it also has some other things thrown in like post-construction wind mitigation. And then Schedule 3 looks at public space and the public realm. We can think about that in light of those conditions that you flagged. You then have jobs procurement, so that's both during construction and in the operational phase at Schedule 4. Station works, which is obviously very specific to this, and it's been the focus really of TfL's input, but not exclusively. Energy requirements at 6, and there is a difference there between the two schemes because 2018 obviously was submitted much earlier, so there is a requirement for them to update, for that scheme would have to update the energy strategy. And then the carbon targets and payments will depend on what that says. Schedule 7 looks at affordable workspace and affordable retail provisions for 2018, just affordable workspace for 2021. And then finally, at the end, you've got the council and TfL obligations. And in terms of schedules and annexures, it's quite straightforward. We don't have lots of codes and various things to append. We will just have the set of plans. And what we've done at the moment is list out the drawings as they will appear in the document. So that that would be the totality of the document.
Thank you. That was helpful. Okay. I didn't have any comments to make. It's just the schedules I'm going to focus on. Everything else seems fairly straightforward and perfectly logical, and it's all there to me. So schedule 1, financial contributions. So we've got site and development contributions, TfL contributions, cycle hire scheme, and way finding. I mean, I didn't have any particular comments on any of that, but I didn't know if anyone else around the table wanted to mention anything with regards to those. It's great you've all agreed, by the way. It just makes my job so much easier, so I thank you for that. So okay. Schedule 2. So again, servicing and deliveries, highway works, travel plan. I've got a comment on the listed building application management plan, but obviously servicing and deliveries, TfL had a concern over the 2018 scheme. Obviously we're in the, it's without prejudice, all of this, but did you have any comments to make just while we're here on that, or without reopening obviously what we discussed at the start of the inquiry?
No, I mean we've reached agreement on the terms of the obligation, as you see here.
Yeah.
I think if we went further than that, we'd be straying into the evidence, which wouldn't be appropriate.
I appreciate the position, and that was made very clear.
You didn't want to add anything else?
No. Okay. Is it anyone else? Anything? Okay. So I had a query about the listed building application management plan. I've not come across this before, so it's just a sort of, what is it, why is it an obligation and perhaps not a condition, what's its purpose and what's it to do? So I ask obvious questions in this just so we can air it and so everyone can understand, so don't think I'm completely an idiot. But anyone want to?
So I suppose starting with your second question as to why this appears as an obligation first rather than a condition, I think in the earlier drafts of the 106 that have been circulated, this particular clause was accompanied by a management fee, much in the same way as the archaeological contribution that would have allowed the council to provide a bit more oversight of the works for listed building, but through negotiation that's fallen away, but the strategy has remained here. I don't think we'd have any particular concern if you decided at this point in time this better sat as a condition rather than obligation. We'd have to agree a form of wording if that was the case, because as drafted, there's quite a lot of detail there and it would need to be a little bit more succinct to be a condition. But in terms of what this is trying to achieve, I think the best place to look is at paragraph 6.3, which covers the various elements of the management plan and the detail that the council would wish to have it in a plan, just to ensure that the significance of a listed building was properly regarded throughout the works.
Thank you. I mean, this came obviously from Southwark Drafting and we're very happy with it. My understanding, and it hasn't been called this here, so it doesn't perhaps go quite as far, but that it's something quite akin to a heritage partnership agreement, which is a non-statutory agreement where you set out specifically the element of works which would go towards the listed characteristics of the building, so that people have clarity as to what can be done and what can't be done without further consent. And my understanding is that this is intended to pull out some of those key requirements, so there is a clear document between the parties which specifies exactly the works which have been approved under this listed building consent, what other pieces could be done without additional consent. I don't know if that's taking that too far, but that's my understanding of
like the shop fit out for, if I was a leasee of one of the units,
precisely
that kind of thing, what would need permission and what. Okay.
and exactly what the scope of the listed building consent works, which are already approved, so people know. Is that really the purpose of why you asked for it?
Yeah, I think my understanding is that it's quite a new initiative that the Urban Design and Conservation team instructed that they would wish to see included in projects of this type. I think we have used this once before in Southwark, and it's something that could possibly be seen as a helpful strategy moving forward. So we're in fairly uncharted territory with this obligation, and I think it may be a belt and braces approach.
And just to clarify, it is just for the listed units on the site, so it's not looking at the hospital, the pub, anything like that.
Yes, it's just the listed buildings that form part of the application.
Okay, and then, does HE have any views on this? Is this new territory for you guys as well?
It's new territory. No, I don't think a strong view. I think the only point in terms of whether it should be a condition or should be on the 106, if it were to be a condition, because obviously relates to the LBC, it should be on the LBC rather than the planning permission.
Yeah.
But I don't think no other views.
Yeah. I mean, is there a specific reason why it was felt it should, as a new sort of uncharted thing, why the obligation was the correct vehicle for this, not a condition?
I mean, I think I would just say that perhaps as a point of principle, our departments are always looking at ways of strengthening the obligations and matters running for land rather than perhaps falling aside as conditions can sometimes do. And I think there was initially a proposal that there would be, as Mr. Glasgow said, some sort of monitoring fee attached to this proposal, which I think has not made its way through the negotiations. So it's a standalone plan at the moment.
Okay. Do you have any views on its suitability as an obligation over a condition?
We don't have strong views either way, but I can see that it would work perfectly well as a condition, and particularly given that there isn't separate payments or anything else that needs to sit alongside it. I think it could be added onto the to the list of building consent conditions. We don't have a strong view.
Okay. Does the council have a preference?
I don't think we do, actually. No.
So I suppose if things are capable of being conditioned, that's what the MPPF tells us to do. So I do wonder, unless there's some specific reason. I appreciate the monitoring fees, which isn't that, if they were there, then that would be the straightforward obligation here. But because I suppose it's akin to some of the other management plans that we've talked about this morning several times. I do think it would need to go on the list of building consent applications. But I guess, because they're much shorter lists of conditions, would you be happy that the risk of it getting lost or missed, if people came in and didn't see it, would you be satisfied that that would be an appropriate place?
Yeah, I think that sounds fine.
Yeah.
I think if it was that next step ahead, which is the Heritage Partnership Agreement, that might more logically sit within, but this is a management plan. I think that does make sense to sit in the conditions, so I'd concur with that.
Okay, if I can ask you to go away, I've got more homework for you now. Go away and look at that in terms of a condition then instead of in this document. Okay, all right. Anything else on schedule 2?
I know we discussed at the outset of the inquiry how the delivery and servicing and the bond, that £100,000 bond essentially sits with the council. The one thing I didn't know whether it hasn't really come up in conversation, but it just was about the community use, which obviously that's one of the provisions. That's at paragraph 5 of the 2018. It's specific to 2018 because it relates to the business hub, which obviously has come up some of the time. You'll see in the definitions how really the terms of that, which is essentially that there's a 10% time requirement between 8 a.m. and 9 p.m. 7 days a week. So out of that time allowance, 10%, or minimum of 10%, has to be open and available to the community schools, etc. And there's a bit more into the definition, so you just need to read the two together.
Yeah. Thank you, that's helpful. Great, thank you. Okay, schedule 3 then, and public space. So we looked at the conditions this morning, and I flagged up the crossover between a lot of them. I don't know if you had long enough in the break to have a think about how this will sit together, and if there are implications for either the obligation, how it's termed, or the conditions and how they're phrased. So I don't mind who we start with. Don't all jump in at once.
Yeah, we had a quick discussion about this in the break, and I think our view is that they do sit discreetly and are to some extent complementary. So the landscape management plan condition that we discussed is a sort of more qualitative piece around the regime that the developer will implement to make sure the landscaping thrives over time, address perhaps any issues around neighbour relationships, those sorts of things, but there'd be a discrete company or a body identified to carry out those works, and it would set out the regularity. The obligations are a little bit different in their tone and content, and they're sort of establishing a more fundamental framework around rights of access to firstly the ground floor public realm, but then separately, where there is reference to management plan in the 106, it's relating to elements of the building rather than sort of the space more generally open to the public.
Can you just give me an example of that I can?
Yep, sure. So if you look at part 1, paragraph 1.1, this schedule looks at the particular management plans that would be secured by the 106. It's looking very particularly at the reception space at the roof gardens in the case of the 2018 scheme. So it's about access into the building rather than more general access to the wider public realm.
Okay. Any comments on that in terms of what we discussed this morning?
Yeah, so I would agree that condition 23, but the numbers are all changing, but the hard and soft landscaping condition, that it does sit separately and it covers things which aren't covered in the 106. And we have, as the drafting has evolved, we have tried to merge the two. So there was quite a lot of overlap in early drafts, and it has settled. I think we do need condition 23, and I can't see that there is any overlap in that in terms of actually the detailed design of the landscaping, etc. Where I think there is some overlap is paragraph 3 of part 1 of schedule 3, so the maintenance. So that maintenance requirement is across all of the public space. Now that includes the public realm, which is very much part of that landscaping condition, but also includes the roof terraces, the access into the reception. And I think looking at what was condition 27, so that either public realm or landscape management plan, the request in the condition is for the plan to cover long-term design objectives, management responsibilities and maintenance schedules for all of the landscaped areas, trees, biodiverse, roof, terrace planting, etc., to be submitted and then to be carried out as approved. I I do think, subject to Southwark's view, that paragraph 3 covers that. We have a 12-month defect period in which the developer is liable for all defects anyway. And then after that, and for the lifetime of the development, we are required to maintain, drain, put in the permanent system of lighting and maintain that, etc. So I personally think there is overlap on that one.
Madam, I think Southwark takes the view. I take my friend's point about that, but I think the public realm on any scheme, on any major scheme particularly, is so important that we've always sought to secure these precise provisions in every 106 that we've negotiated on a scheme of this nature. And as I said earlier, the obligations, run the land, they bind successive owners, and the long-term nature of them means that they are, in our view, a better fit in the 106 than simply as a condition that could be overlooked or fall away with the passage of time. I think there's a greater chance of us securing the important maintenance and cleaning of the public space if we have it as an obligation rather than a condition.
So in terms of, do you think strike out that other condition, and I can't remember which number it is now, and just rely on the obligation so there's no duplication, or do you want both? Or
sorry, I think we would have to make sure that there was absolutely nothing in the condition that is not covered in the obligation first. So I think we would have to take that away and give that some serious consideration, because there might be something initial and short term about the condition that could be retained, and the longer term provision could be retained in the 106.
I mean, I'm given we've got a whole schedule about the public space, and it is complicated and it's quite tightly defined in the obligation. I think conversely to the listed building management plan, I think probably the place is for it in the obligation rather than the conditions, just to give you that certainty. But I think if you can go away and just check that the obligation is doing everything that you want the condition to do on the obligation, I think that would be helpful. Hopefully not too onerous either.
Yeah, thank you, Madam. I think the council would be grateful if that approach was followed through. Thank you.
Yeah, and to clarify, that was actually what I was meaning in terms of deletion or potential deletion of the condition. I think it does neatly sit in section 106, and I wouldn't suggest that we take it out of there. It's just whether or not we can all agree that it's fully covered.
Yeah.
Equally, those two things at the moment, the 106 is looking at long-term management and maintenance. This is requiring that plan to come forward at a certain point in time. I don't have a strong view on having an element of overlap either. So
I think if you can just get your heads together and sort of work that one through, hopefully it'll be fairly obvious once it's just looked at in a bit more detail rather than quickly now. Okay. So any more comments with regards to the public space before we move on to the next schedule? I didn't have any more comments to make.
I think the only point to perhaps draw your attention to, Madam, is for both the different elements. There are there's an ability to close in certain circumstances. That's been more discussed in relation to the roof gardens, just to allow for some private events, and that is defined by way of a permitted closure days, which is a maximum of 20 days across the year. And then there are additional restrictions on how long in any one stretch that can be, or how many of those days can be at weekends, that kind of thing. That's in 1.5.2 of part 3. So I think that's a point just to be aware that has subject to discussion and is all agreed.
Right. The closure dates, the hours. Yeah. Okay. Great. And then, so moving on, schedule for employment, training, construction apprenticeships and local procurement. Again, fairly standard section 106 stuff. I didn't have any particular comments unless you wanted to raise anything or.
The only point I think is that if you actually go through, as I did last night with my calculator, to work out actually the potential sums, which obviously we don't intend to not provide any of these spaces, but if in the event that any of the courses or jobs during construction or long-term employment didn't come forward, there are requirements in Southwark to then pay out a certain amount of money per placement that you don't secure, and the numbers are pretty substantial. So for the construction, they're in excess of 500,000, and the operational stage, they are obviously different between the two schemes, but over they're about 1.4 million-ish, 1.38. So they're not expressly set out. You have to kind of go through and calculate them up, but the numbers are quite substantial.
Any comments?
No, none especially. I think as you've set out, it's a relatively standard set of obligations. It follows the methodology described in the Council's Section 106 and SIL SPD. And I think from the Council's perspective, the priority really is ensuring the numbers in clause 1.4 are attained and that the opportunities are extended to unemployed residents. So hopefully those payments don't come to pass. But they're largely included because if from the outset we know that a particular developer hasn't got the capacity to deliver the training scheme themselves, there's an opportunity to sort of make the payment, and the council can engage with its partners to carry out the equivalent process.
Thank you. Okay, schedule 5 then, station works. Any comments?
So the station works are to provide a new entrance and exit from the Borough High Street London Underground entrance. They will come forward primarily in accordance with the development agreement that is to be agreed outside the planning world, as it were. And the purpose of these obligations is to ensure that that development agreement is entered into prior to the commencement of the development. And actually, that just reminds me that this needs to be one of the clauses that comes into effect before implementation. So I'll pick that up separately. And so this ensures that the development agreement is entered into, and then that the station works are completed prior to occupation of the office floor space. The office floor space being the primary generator of people in the area. And just to pick up on what was said earlier, TfL enters into this agreement, but will ensure that we'll use reasonable endeavours to procure that LUL enters into the development agreement, LUL being part of the broader TfL family. There's no LUL interest in the land that is bound by this agreement. So it was not felt necessary for LUL to be a party, but TfL stands in its stead. And we are content to have agreed to the terms.
Great, thank you. Any comments from anyone else on that?
Sorry, the only small point to note, given that you had asked the question about Coney Bear House and the additional list of building consent applications, is that when you look at the detail of this scheme, and the reason that LU don't have an interest within the site is that the red line boundary for the planning application runs essentially along the back of our walls. There are two walls, the LU's wall, our wall adjacent, and our red line boundary is right up that dividing line. So the planning application facilitates delivery of that, because until everything on our side is moved away and the site is cleared, that exit can never happen. There may well need to be a very miniature planning application that goes in, because I don't think under TfL's permitted development powers that they would have ability to do works to the station to knock through that wall. So there would be a supplemental planning permission. Now that would all be wrapped up within the development agreement because that requires all consents, etc., prior to the start of any work. But I just wanted to clarify that is exactly how that's kind of come to being. And I think essentially that's because at the beginning of this process there wasn't an agreement with London Underground that they wanted these works, whereas obviously now there's assigned heads of terms, they're very supportive, they want these works to happen. To the station works, I should clarify. That's why at the outset the red line wasn't drawn bigger to actually encompass those station works, but the design has since all been agreed.
Okay. In terms of the council's point of view, then would planning be required? That is putting you on the spot.
Can I answer that? Unfortunately, yes.
Yeah.
It's works to a station. And whilst the internal works to the ticket hall is permitted development, regrettably, knocking a hole in a wall is not.
Okay.
But it should be a very simple application. It's one of the things we would do quite often.
Okay, thank you. Okay, so we're in obviously obligations, but I'm mindful that the opening up and the new entrance is cited as a planning benefit. I think the weight's slightly different from the parties. Does that have any implications for that? I'm sort of straying back into planning stuff here. It's just because I didn't realise that there was this issue. So
it might help me to say perhaps that we are content that these obligations secure the delivery.
Yeah, okay.
There will be numerous consents and procedures that have to be followed before it can be delivered, as it were. But the structure of this obligation is to ensure that all of those things happen at the right time, so that before works commence, we have the development agreement in place, and then before the scheme is occupied, the station works are delivered. If for any reason that was impossible, it wouldn't be possible to then occupy the development. So we feel that those sort of Grampian-style obligations sufficiently secure the delivery.
Thank you. I think that's one of the reasons that TfL have been brought into the 106, so that you have that certainty. It's also why we agreed, possibly against our better judgment, to allow for a commencement, such an early restriction. So we can't, that's the first material operation. We can't do that without the development agreement being in place, and that's to give you that certainty that there is no way that this scheme could come forward without the development agreement being agreed. So that's, in other circumstances, I suspect we wouldn't have agreed that, but that's where we're at, to allow that certainty.
Okay. Finally, the council have a view on that?
Only to say that I think we had acknowledged back in making our statement of case that this was an issue and that there'd be a number of steps to go through to secure the works of the station. I think we're also content that the obligations that we now have in Schedule 5 go as far as we can in this forum to addressing that point.
Okay. All right. Thank you. That's helpful. Okay. Any more comments on the station work? No. Okay. Energy. Again, the energy strategy, fairly run-of-the-mill planning stuff. District heat network. I've seen similar things before. BC monitoring. That's a new one on me. The snappy title. Any comments on any of that?
I mentioned earlier, this is one of the areas that 2021 differs. So just worth being aware, 2021 obviously links to the application energy strategy.
Yeah.
2018 requires an updated energy strategy to ensure, again, that you've got that certainty that both schemes actually would come forward with the same level of energy compliance. BC, it would be lovely if we had a representative from the GLA, because that's standard GLA wording, which no lawyer is able to negotiate. So that's how it comes and that's how it goes in.
Okay.
It's fairly new, and it's across all of London, every scheme that we have that is referable to the mayor, so all the major schemes will include be seen monitoring wording, and it looks exactly like that.
Yeah. Okay. Yeah. It's not come across it before, and just interesting title. Okay. Or any other comments on Schedule 6? Okay, Schedule 7 then, affordable workspace and affordable retail. So I think there's been a fair amount of negotiation on this point, and I know Mr. Villas, you wanted to stay specifically for this section. So perhaps sort of introduce what's happened, what's now in this latest obligation, because I think, is it now 10% affordable, if I'm right? So yeah, if you can just talk me through it, and then we'll get to Mr. Villas.
So one of the areas where the schemes are different, when the 2018 application was brought forward, there was no policy requirement, there was no affordable workspace within, or requirement within the borough. I think that's right, or it certainly wasn't a 10% obligation anyway. So there was an inclusion of 2.3%, something like that. And also at that point, there was encouragement, I think, from officers to have affordable retail provision as well. So the 2018 scheme has the affordable retail, had a very small amount, or an amount of affordable workspace. Because it's non-determination, obviously, once we got to the point where we were appealing, we said, look, we want the two schemes on many of the benefits to be equivalent or comparable. So we'll bring the 2018 scheme up to current policy compliance, which is what we would have done had Southwark been taking this to committee, because they're obviously going to be determining in light of current policy. The architects, I think it's fair to say, we were trying to keep it sensible, so like an entire floor of a building, so we didn't have subdivision within floors, particularly within the tower, because those floor plates are quite large. And so we'd got to a point of 9.7%, which we'd all agreed, and I think Mike said in his evidence, pragmatic approach, that was agreed with the council. It made sense. That's some provision in the terrace, some in Keats House, some in the tower. And then to bring it up to policy compliance, we'd always said, from when we had the 2.3% provision, we'll give you a payment in lieu. The problem is calculating that payment in lieu, because there are different market rents across all of the different areas of the scheme. The investment yields aren't known. In a scenario of a public inquiry, we couldn't share sensitive commercial information, and I think everybody understood that. So what's happened very recently is we've said, that's fine, we'll provide the top up. So it is a 10% for both schemes in different places, obviously, because of the different design. There's a 10% on-site provision. The 2021 has an additional slight, complication or a factor, which I fully admit I'd left out of the drafting as in error until we realised that a couple of days ago when we were because 2021 is lagged behind. We've all focused on 2018. The 2021 scheme has a flexible office retail unit, which is at ground and ground mezzanine of the main building. And that, obviously, if it were to come forward as office, would up the amount of office floor space, and therefore the 10% provision wouldn't be quite 10%. So we have agreed with the council drafting, which I think is in yesterday's version, but it only came into yesterday's, which basically says in the event that it comes forward for office use, or it can't be used for office use unless we've notified the council that that's what's happening, and we've agreed either the additional provision on site to bring it up to 10%, or a payment in lieu in relation to that, and it will be a very small area that makes a difference. And that drafting has this morning been agreed, so that will go in.
Where's that in the 2021?
So it will be in paragraph 5 of that Schedule 7. I haven't got that in front of me, but it should be.
The red there. I've got a track changes version.
Has it got a flexible office retail unit? Yeah, that's it.
That's it. Yeah. Okay, and that's all agreed. Yeah. Okay.
And then I think the other thing to say, so it's always been agreed from the outset, 25% discount from market rent. there's a fairly complicated process of how you determine market rent with Rick's Red Book, and one valuer, if you don't agree, you go to another valuer. If you still don't agree, you go to a third and you take an average. But that's all been agreed. The service charge conversation has been quite a big point for us, because that's obviously it's a 30-year provision from first occupation. There's the 25% discount against rent, plus there's a 6-month rent-free period for both schemes. That had all been costed in to budgets and viability, etc. A conversation hadn't happened about the levels of service charge ongoing, and in a scheme of this kind of quality and scale, some of the service charges could be quite significant. So on both sides, the council were suggesting slight concern if we don't put a cap on or some kind of restriction. We were saying, well, we hadn't budgeted that in. So that's been, nothing else really has been a point of contention. It was that, but we have agreed a £4.50 per square foot per annum cap. So it can't go beyond that. That's significantly more than a 25% discount on service charge. So there's a 25% discount against rent, and there's a much bigger cap. And that goes across all areas of the affordable workspace across both schemes.
Okay, and that's all agreed?
All agreed. And then the last thing I think is to say that the hospital this morning have made a request.
Yes, so did you want to explain? I'm not sure if I've seen fully the correspondence or emails. So.
Okay, well, apologies, it was fairly late. So simply the position of Guy's and KCL is that, having had discussions with the appellant over some time, going back over the course of the two applications, about taking some or all of the affordable workspace, the request is quite a simple one, really, that within the definitions, as opposed to the schedules, we don't have a problem with the schedule in terms of how it's set out, in terms of the space, the location particularly, or the discount. It is what it is. If it's policy compliant, we can't ask for more. But we would like the fact that Guy's, as a key component, and KCL, of what is now an innovation district, it's around biomed industries. That's the reason that district, to a large degree, will exist and does exist. That Guy's and KCL at least are referred to in the definitions as a potential, so one of a number, but potential provider and potential tenant. We don't think it's a big ask. It just allows a little bit more clarity around their position. But at the end of the day, it could go somewhere else. But that's as simple as that, really. It's the two definitions: one as provider, one as eligible tenant, that they are referred to within that list. It does refer to public services already. It refers to charities. Obviously, it refers to the developer as a potential provider, but we'd just like to see reference to GSTT and KCL within that list. And that's it.
Okay.
Thanks.
Well, we will be guided by the council on this, and I think, but we don't have any qualms about it. We had taken from your email this morning, and apologies if that's my mistake, but I had thought it was just into the definition of affordable workspace provider. That's at the level where a provider then has to enters into an affordable workspace lease, which includes your restrictions in terms of the affordable levels of rent, service charge caps, etc. But that provider then sublets or licenses out to eligible tenants. So I can understand the logic of saying that you also need it in the eligible tenant definition. That does include already public health services, so arguably it would be in. I think I'm talking from experience on other schemes where Kings, and because of the SC1 cluster that's coming forward at London Bridge, and I'm working on a few of those schemes, I think the thing that sometimes could cause complications is how those end users evidence that they are eligible. So as opposed, because Kings as a hospital or Guy's are commercial operators, they couldn't, for example, necessarily just use it for, I mean, they wouldn't use it for an operating theatre, but for their usual purposes, it needs to be for their kind of startups, the moonshot, that kind of thing. So I think we might need to think it through if it also went into eligible tenants. But very much that's a point for the council. We're easy, and we've, appreciate the fact there's been ongoing discussion for a long time. The scheme is coming forward within that SC1 area, and it makes a lot of sense for medtech to go into these buildings. I would say that affordable workspace provider, Lim D, allows for such other provider as may be approved, and that's where the reason we hadn't pushed for this before was because I was assuming, look, once we get an agreement with the hospital, we would put that to Southwark. There's no way that they're going to say no. So I was relying on Lim D and Public Health Lim B. So that's why we didn't ask for these as the appellant. But over to the council, ready?
Yeah. Okay.
Well, yes. We got notice of that point, of your point, actually, this morning, Mr. Villas. So we've taken instructions from the local economy team, and they've advised that Guy's and St Thomas's Trust have already made a request to be put on the council's workspace provider list, which is referred to in this document. So that assessment is going to be undertaken, I think, late summer, autumn. So that would be independent of this particular application and appeal. With regard to the status of the hospital as an eligible tenant, we've taken the definition from policy P31 and the fact box, so beloved of council for the appellant. The definition of affordable workspace occupier is where that has come from. But I think we'd be rash if we said, yes, we can agree to that in this forum here and now. But as I say, Guys are being assessed as a workspace provider. And although I note that the eligible tenant occupation, definition doesn't say and any other persons approved, it's that kind of occupier that this whole provision is aimed at assisting. But Guys were being looked at the higher sort of provider level rather than being occupiers themselves.
I mean, obviously, having had a quick look at the definitions again and just reminding myself, I mean, the eligible tenants, it is a generic list. It doesn't specify, and the concern, I guess, for me maybe is, will someone complain because they're not named in this in the same way? I mean, certainly from my reading, Guys isn't precluded from this. Does that give you enough comfort, or you're adamant that you want the extra and the recognition specifically in here?
I think we appreciate that it can fall under those. In fact, the two headings, I think, either tenant or provider. And again, I suppose it's for clarity. It's just to emphasise the fact that this isn't just any other entity in this local area. It's not even to say necessarily that it has priority, but it's just emphasising the fact that it's an important presence. But no, I think we appreciate that it can still be done under the existing clauses. But I think it just gives a little bit of extra weight to it. I'm aware that Guys have applied, but they're not there at the moment. So we don't have control over that. That's for the council. So again, it's just to maybe not look at the worst case scenario, but to include them through this route, just in case. I suppose. But I'm sure I don't see why why the council wouldn't accept that. But it's just an extra added, I suppose, comfort that it can be delivered.
So you would say?
Yeah, it's just, I think knowing that application is ongoing, which makes a lot of sense. I hadn't realised that was the case, but it makes a lot of sense because the SC1 initiative is being brought forward by GSTT, King's, Lambeth and Southwark. So this is a supported medtech global cluster, etc. But I think I can understand why the council in this scenario, where we're going to have a very limited time to, well, let's see, but a limited time to agree and complete the agreement, if that application is ongoing and there is a process, I'm sure you're going to get added onto that workplace provider list. And if you didn't, we would make an application under Lim D for a specific approval. But I think that's very difficult for Southwark to just add it in because you're bypassing a process which is underway with other teams across the council. And I can't see how the council's legal team are going to get consent to do that when the application hasn't been considered yet.
Do you have any more information about the process and when the application is likely to be looked at in terms of the workspace provider list? Is there any more sort of clarity you can provide?
The information I've got is that they're looking to, our colleagues in the local economy team are looking to refresh the workspace provider list late summer, autumn. The purpose of the list is it's a list of providers that the council has reasonable confidence in sharing with developers and have confidence that these operators have experience in delivering affordable workspace. And the point that's just been made by Louise is that we don't have the authority here to bypass that procedure which is already underway, that process which is already underway, and agree to add in the hospital as a named workspace provider at this point. It's not because of any lack of confidence in the hospital or any failure to recognise their status. It's simply that the process hasn't been completed yet.
I would just one last point, which is that in some of the other schemes coming along the street, negotiations are more advanced with Guy's and King's, and so some of those spaces have been specifically designed for hospital use, and that includes the affordable workspace. So we've heard a lot about Vinegar Yard, for example, on this project, and that is coming forward with certain 10 of those floors of the tower are being specifically designed for hospital stroke medical R&D, and the King's and St Thomas's are named as the affordable workspace provider in there, or at least they have an exclusivity option on it. So there's clearly support from the council, but I do think, I guess one point on that is that the hospital ought to take comfort from it. I don't think we need to try and bypass anything here, and I think realistically we might struggle. But also coming to the planning benefit, ultimately the benefit and the weight, and others will talk to this, but has been put on the provision of affordable. Now, whilst there's an ongoing conversation and an intent for that to continue, I don't think that as such changes the weight being put on that benefit. The benefit is the 25% discount, the significant cost of the cap on the service charge, the fact that the 106 requires it to be eligible tenants and it to be policy compliant, small and medium businesses, etc. So I'm not in any way suggesting we want to bypass, but at this point we don't know that King's will definitely take all of the workspace or some of it, and I think and therefore the section 106 for your purposes doesn't need to do any more than secure the affordable workspace, which it does. So
Mr. Villas, did you want to?
I don't think there's much more to add other than that it's clear that Guy's and King's are recognised. These opportunities don't come along very often. From our perspective, there have been lengthy discussions and nothing concrete is in place, I think it would assist the process from a client's perspective to have that recognition through the legal agreement. I don't think it's a big ask. This is not a run-of-the-mill sort of neighbouring business. The presence there is really why this area has grown into what it is, and why people want to be there, and they have a meaningful requirement for affordable workspace. So, probably leave it at that.
I don't know if anyone can answer this, and if you can't say, in terms of the other schemes where guys and KCLR, was any of that reflected in the Section 106 agreements for those schemes, or was it similar to this?
The Vinegar Yard 106 is currently confidential, so it's not been concluded, but it's a very different scheme because there is an exclusivity period being baked in. So the mayor's decision is based on the fact that a certain number of the floors will first be offered to the hospital for hospital use, and if that doesn't come forward in a certain time frame, then it can open up to still a restricted use, which is an R&D user for the purposes of the SC1 cluster. So yes, Guys and Tommies are baked into that Section 106, but the design has been brought forward for a hospital, so it is different. But in the event that the floor space does come forward as a hospital rather than the wider R&D, then there is an element of their affordable workspace which sits with that cascade, so it has to be offered to the hospital. And therefore it's a clear understanding that the hospital can be an affordable workspace provider within Southwark.
Okay. It's thrown me this.
Can I just on that last point, actually, I mean, I suppose from my perspective, therefore, what is being asked for is actually less than other neighbouring schemes. Because there isn't any exclusivity request or requirement here. It's merely that they're identified, as they have elsewhere, as a provider who basically needs space.
I mean, obviously the negotiations have been going on a long time. This has come in this morning. Why has it been left till now?
I think partly we only saw the 106 on Friday. To be fair, I mean, the appellant's been very aware of the interest. So I suppose the same question could go to the appellant. And there have been discussions around other uses around the museum, which you've seen reference to. None of that's been pushed for. We know this is a different application that might come back. There's been a lot of goodwill between the parties. So I don't think it's a big request that they're just on the list. It's as simple as that, really. But no, I appreciate it's late to put this forward.
I think that's entirely fair in terms of timing. That hasn't been a willful position on our part. The Section 106 has been moving very rapidly for the last few weeks, as I think a few bags around our eyes can tell everybody. Until Mr. Villas and that the reps came in, which was during this inquiry process, we hadn't anticipated engagement in the conditions or the 106. It just hadn't been on our radar. We know that there have been discussions. There's a lot of goodwill. There's a letter before the inquiry in terms of support for that moonshot scheme and putting space in. This allows for that to happen. So it's really it's just the issue is really in terms of Southwark now being able to say, yes, we would put you in, which essentially gives you the same status as if they were on the workspace provider list when there is a live application. I just think that's a bit tricky. It's not, from our perspective, as you said, there's no exclusivity, negotiations will carry on, but the public benefit relates to affordable workspace. So,
okay, Southwark comments.
Madam, I'm not really sure that I can add anything that will help in this circumstance. as I've said, looking at the wording, we have public health services are suitable, eligible tenants. Guys have an application in to be an affordable workspace provider. This has been raised quite late in the day. I personally am not aware of any discussions or negotiations that the appellant has had with any potential occupiers of the space, apart from the letters that we've seen in the evidence from King's. So much as I'd love to be able to move this on, I don't really see that I can do in the absence of any authority or instruction.
No. So in terms of obviously my role here as planning inspector, does this make any difference? So we've heard obviously what the appellants have had to say in terms of public benefits and weight, and does that, I don't know if Mr. Philpott wants to.
And I've just been making notes as to what we might say in closing about it, but it is essentially, as I understand it, there's no reliance being placed or weight being placed upon KCL or the hospital as a specific end user. So although you have the letter which sort of illustrates one potential person who might use it, might be them, might not be them. So it is, I think, has been fairly put, it's the affordable space, which is the element which is proposed to be secured, and any judgments about weight have to be based on that and not on the particular identity of an individual end user.
Okay, thank you.
Possible suggestion. Thank you very much to my learned friend. Which is that we perhaps put something into the eligible tenant definition that specifically references the life science sector in SC1. It doesn't necessarily go as far as to give you the name, but it maybe gives a little bit more. You have got in there at the moment public health services, but we might be able to extend that to life sciences.
I think a lot of this is obviously on the spot thinking from me included as well. It's a test of the brain before lunchtime, this. I mean, at the end of the day, we're going to finish this session. We'll agree a timetable for the obligations to be finalised, submitted and signed. And I've got to consider the development in that respect. So I've heard the point. I think it's maybe a slightly separate thing that the council needs to take instruction on, and if that does appear in the obligation, I'll consider it if the name, and if not, I'll consider it as is. And I think that's probably as much as we can take from this forum today. I think what I would appreciate though is just some clarity on this workspace provider list process, because you said it's late summer and autumn. I mean, we're mid-August roughly now. To me, that's late summer and September's autumn. So I think just a little bit of clarity on that, and appreciate you're not in a position to answer that now because that's with another team, but that would help. But I think other than that, I think we'll just have to leave that one there, and I'll see the obligation in terms of what it comes out as when I get the signed version. Does that seem reasonable to everyone? Yeah. Okay. Well, thank you. I think you're yeah. On that bombshell, as they say. Thank you. No, thank you for your time today. Okay. Anything else then in terms of affordable workspace and affordable retail? I mean, obviously for the 2012. Doing it again, aren't I? 2021, there is no affordable retail, it's purely affordable office, and that difference is reflected in that. But anything else to pick up on and say? No, we've said enough. Silence. Okay. I think that's got the specifications in the annex. Schedule 8, council and TfL's obligations. Any comments on those? Yeah.
I think the only last point that we haven't, I don't think we need to go into in any detail, but it's just to say, unlike some 106s that you may have seen, this is not a combined 106 with a 278 together. So the highways works will be subject to separate highways agreements, and there'll be one with Southwark for the Southwark Road, obviously, or roads around the yards, and one with TfL for St Thomas Street, and the work's coming forward there. There are indicative plans attached, and they'll be marked as indicative, which have been agreed, and some changes made this morning. But the detailed design sits within that Section 278 agreement process, and that will obviously the 278s have to be in place before any works can take place on the highway. The highway works have to be completed before occupation. So just clarification.
Okay, that reflects your understanding as well, just for
exactly. Yeah. So there'll be a further process, but we're happy with where we are at this stage.
Okay. All right. Okay. Any final comments on the obligation 2018? Any additional comments to make on the 2021? Nearly did it again. Anything you want to draw my specific attention to?
No, I think I tried to do it as we went through.
Yeah.
I did have a question for the parties, which I meant to ask this morning, so apologies. But in terms of, we're obviously come to timings for execution, but it would be useful to know everybody's position in terms of DocuSigns for electronic execution or hard copies and physical signatures. And I meant to ask before and I haven't, so apologies.
Okay.
So change the time scale, that's all.
Yeah. So the council has its own separate electronic platform called Cinerix, but it works exactly the same as DocuSign. It's just cheaper. But we found out yesterday that you can sign your agreements using DocuSign, and then if you send the agreement, the PDF to us, we can then upload it to Cinerix and sign it using our platform. So it's not an issue.
We think we can use DocuSign. We're not 100% sure. So do you mind if I check and confirm? But we think so.
Gosh, isn't technology marvellous nowadays? Okay, so because that has implications in terms of time needed to sort of finalise. There's a couple of changes to be made, as we've discussed. And then the issue with guys as well, that request there, which needs some consideration in terms of the council's point of view. I'm going to be, I'm not going to be writing this up next week and submitting it to the Secretary of State in any time soon, but I don't, obviously the obligations, do factor into my report writing and stuff. So I don't know what a reasonable time frame is. And bearing in mind, it's also summer and people might go away having done a 4-week inquiry. They might want a holiday afterwards. So I don't know if anyone had any thoughts. With smiles, holiday show.
It's become fairly standard, well, in my experience, to agree 2 weeks for execution, but that is when the document is entirely finalised. I would prefer to keep it fairly tight, I think, simply because people going on leave, I don't know if that's long enough. Your end, I'm equally very flexible. I think DocuSign speeds things up because people can be anywhere, and it's electronic.
Yeah.
We don't have physical copies going around the houses, and I'm assuming, Madam, that you're comfortable to accept an electronic.
Yes. Yeah.
Okay.
Yeah.
Yeah, 2 weeks is fine for us. We've got signatories available.
We're not sure. We might need a little longer just because of the availability of signatories. When's the 2 weeks from? Is it from the close?
So it'd be
when are you closing?
So we close tomorrow, the 10th. So 2 weeks after that would take us to the 24th of August. I mean, the week after is the 31st, 3 weeks. And then we're on obviously into September.
Yeah, 31st I think would make us feel a little
3
bit
weeks
more comfortable. Yeah. Just because it's August and there's bank holiday.
Yeah. It's a tricky time of year. Is that?
Yeah.
that fit? I'm comfortable with that. I think that seems reasonable. I don't want to go too long because I don't want to lose
I
the
understand.
time.
I think we're in the council's hands because whilst we'd be uploading to Synergix or whatever it was, it requires people. There's more admin on your side. So if you're happy with that,
yeah, we'll be fine with the 31st of August.
31st.
And we'll have signatories.
Okay, great, thank you. Okay, any more comments to make on anything conditions or obligations related, or forever keep it to yourself? No, silence. You're all stunned into silence today. Okay, well, not the most riveting of topics, but really important. And thank you for all your efforts into it. I do really appreciate it. We've got before 1 o'clock as well. That's good. I'll make the shard time slot that we've got. So thank you very much. So we shall reconvene tomorrow, 9:30 for closings, and I'll talk to. I mean, obviously, not everyone's here, but we'll have a fairly relaxed day just to allow people to finesse their thing. I think it'd be council first though, so you'll have a busy night, unfortunately. But are there any other housekeeping points to raise?
we're just sorry. I feel like I keep pressing my
No. Channeling your advocate.
Exactly. I want to be solicitor advocate. There is the public benefits, the homework,
yes,
that was set. That I think on our side is agreed. I think are we nearly there?
I think we're there. I just double check my inbox to make sure I haven't had another iteration, but I think we're there.
Thank you. And then the only other thing I've still got on our list is an update or an agreement, however we resolve the position on the 70% pedestrian movement piece. I think we're pretty much agreed. Is that right?
Sort of looking across at Aidan, I think I've had various conversations with AHMM now to understand the work that sits behind that, and I think we've got enough information now that I can pull something together to set out a position as we understand it.
When do you think that's likely to be?
I'll probably try and finalise that now this afternoon. We've got a bit of time.
Yeah. Okay. So then, and then conditions as well, just sort of mopping up documents that we expect.
So I think today, hopefully, we could do the public benefits. And so, just so I'm clear, on the pedestrian piece, are you intending to submit something, or are you going to say we're happy with what's already gone in? I just wonder whether we might need to either review it. I don't really want to have to submit something in response to your submission, but
I can send it through to you first so you've got sight of it, but I think we will pull something together.
Thank you.
Right. Anything else from anyone else in the room? No. Okay. All right. Well, thank you, everyone. I shall see you tomorrow for closings. Okay. Thank you.